I represented a buyer who settled on a property in December of last year. In July, the basement of the house flooded. The sellers marked no on the disclosure question, any leaks or evidence of moisture. The seller's insurance company told the buyer that the sellers had previously filed an insurance claim for $40,000 for a previous flooding incident at the house. According to the buyer, the sellers then increased their insurance coverage for flooding. What recourse does the buyer have?
A buyer may have a claim of misrepresentation or fraud against the seller. A misrepresentation is any manifestation by words or other conduct by one person to another that, under the circumstances, amounts to an assertion not in accordance with the facts. Fraud is defined as an intentional perversion of truth to induce another, in reliance upon it, to part with some valuable thing belonging to him or her, or to surrender a legal right. You should instruct the buyer to obtain competent legal advice. Remember that under Maryland law, a seller is required to disclose the existence of known latent defects. Latent defects are defined as material defects in real property or an improvement to real property that A, a buyer would not reasonably be expected to ascertain or observe by a careful visual inspection of the property, and B, would pose a direct threat to the health or safety of the buyer or an invitee or occupant of the buyer. It's clear the seller had knowledge of previous instances of flooding on the property. The question is whether the seller was aware that the flooding issues were ongoing and didn't disclose. As an aside, licensees must disclose material facts that they knew or should have known that relate to the property. A material fact is defined as a fact that a buyer would consider important when making the decision to buy the property or on what terms and conditions to buy the property. If a licensee knew that the house had a flood and that the seller remediated the flooding issue and repaired the damage by hiring a licensed contractor, in our opinion, this is a material fact and should be disclosed by the listing agent. If it has been less than 1 year since settlement, the parties should be reminded that the Maryland Realtors contract requires mediation before court action. If the buyers would like to pursue mediation, they may contact Maryland Realtors for more information. Finally, under Maryland law, a civil action must be filed within 3 years from the date it accrues. If fraud prevents a person from filing a lawsuit, the time the individual has to file the lawsuit is tolled or paused until they discover the defect or, through the exercise of ordinary diligence, should have discovered the defect.